guests in the previous session, the next theme comes naturally to all our minds. The theme is Strengthening ADR Ecosystem, Institutional Framework for Mediation and Arbitration. This discussion will focus upon topics like making India a credible arbitration hub, improving enforcement and neutrality in arbitration, institutionalizing mediation practices post-Mediation Act 2023, and phasing out ad hoc arbitration. And to take this theme forward, our guests have already taken their spaces, and I would now like to call upon our moderator for this session. Please welcome Ms. Sharmistha Chakrabarti, a partner at Skadden, Arps, Slate, Meagher and Flom in Singapore. We're truly privileged to have you here today. I would now like to invite our guest of honor, Honorable Justice Hemant Gupta, Chairman of the India International Arbitration Center. We are truly privileged to have his leadership in promoting institutional arbitrations in India. We also have Ms. Anju Rathi Rana, Secretary of the Department of Legal Affairs, Ministry of Law and Justice. Also joining us today is Shri Nakul Diwan, Senior Advocate, Supreme Court of India. We are truly privileged to have his expertise and insights with us today. We also have Ms. Marique Paulson, Secretary General, Counsel for International Dispute Resolution of the Kingdom of Bahrain. Please also join me in welcoming our guest, Ms. Neeti Sachdeva, Secretary General and Registrar of the Mumbai Center for International Arbitration. Joining us is another wonderful guest, Ms. Shwetha Bidhuri, Director and Head South Asia for the Singapore International Arbitration Center. We also have with us another guest, Shri Tariq Khan, the representative of the Dubai International Arbitration Center. And finally, please join me in welcoming Shri Tejas Chauhan, the Regional Director for the International Chamber of Commerce in Paris. Also joining us today, Ajay Kumar Arora, Joint Secretary, Arbitration, Government of India. And the GCAI representative joining us today for this session is Shri Rajiv Chauhan, the former Group General Counsel of Pernod Ricard. We are truly privileged to have his insights with us today.
So are we ready to start, or should we be waiting for Justice Gupta coming?
We're just waiting for 1 minute. I believe they're just joining us. I will introduce our guests, and we're just waiting for them to join us now. Thank you so much for joining us, sir. I would request now to please commence the session.
All right. Well, thank you. Sorry for the delay, but now at least we're at quorum, and let's get this started. At the very beginning, what I'd like to do is say a very big thank you to the GCAI for their untiring efforts at organizing this conference and really herding us together into this room. So a big thank you Sanjeev, for having us here. The conference is really an impressive one. It's bringing together really the key end users of arbitration, the general counsels, You are the community that we, the service providers, are here to provide the services for. So thank you for coming. Thank you for attending. And the agenda today is also very appropriate. In this global economy, it is an understatement to say that India is a key player. Tariffs, sanctions, other obstacles notwithstanding, cross-border trade remains flourishing, as does domestic growth. And India's strides are really in the direction of achieving developed nation status by 2047. With that in mind, our topic today will focus on how to develop India's arbitration and ADR system to support the country's policy goal of Viksit Bharat by 2047. And that is, I can see written in the background, reimagining India's legal foundations for Viksit Bharat of 2047. And today we're going to talk with my esteemed panelists about the arbitration and ADR system specifically. I have with me 6 esteemed panelists, many of whom require no introduction. We have representatives from the judiciary, who are the decision makers in the arbitration ecosystem. We have representatives from the government, who represent the policy makers. And we also have representatives from the arbitral institutions, international. We also had someone from the domestic institution, but unfortunately she had to leave. On the dais with me today, to be a little bit more specific, are Honorable Justice Hemant Gupta. He was formerly on the Supreme Court of India and is now the chairman of the India International Arbitration Center. We have Ms. Rathi Rana, who's the Secretary, Department of Legal Affairs, Ministry of Law and Justice. We also have with us Mr. Rajiv Chauhan, who's at the very end. He's the former Group GC of Pernod Ricard. We have visiting today our country, Ms. Marike Paulsen, who is the Secretary General, Counsel for International Dispute Resolution for the Kingdom of Bahrain. Right next to her is Ms. Shwetha Bidhuri, who is the Director and Head South Asia of SIAC. Next to her is Mr. Tariq Khan, who is the Head of International Arbitration at DNCO Dubai, and he also sits as an arbitrator at the DIAC. And last but not the least, I have the pleasure of welcoming Tejas Chauhan, who is the Regional Director of the ICC. That said, to kick off the conversation, what I would quite like to do is to invite Justice Gupta to share his experiences with arbitrating in India. Sir, you're a former Supreme Court judge. You have decades of experience on the bench. But now you've pivoted a little bit, and now you're looking at justice outside of the courts. Sir, what has your experience been with arbitration, specifically arbitrating in India?
Good evening, everyone. We are already running late, so I will be brief. The difficulty in Indian arbitration ecosystem are manifold. One are legal, one are procedural, one is of mindset. We have in India grown with the ad hoc arbitration. Since the 1940 and 1996, we have ad hoc arbitration, institutions we have never dwelt. No, it's very difficult to change mindset from ad hoc arbitration to institutional arbitration. But I think with the effort of all, particularly general counsels who are representing large section of private sector who are in dispute. Public sector undertaking is one sector. The private sector is represented by the general counsels, and today, unfortunately, we are with them. If we change mindset, it will be at least people can opt for institutional arbitration. But even opting for institutional arbitration is not and all. That is starting off another problem. Our legal ecosystem is not all that consumer friendly, meaning thereby disputing parties. There is intervention by court at every level, from interim orders under Section 9, then appointment of an arbitrator under Section 11, then a revocation of arbitral authority, termination of arbitral authority, then Section 29, extension of time, and then objections against the award, and then execution. And for courts, the commercial matters is not a priority. There are many other matters, particularly related to life and liberty, and other public interest matters. The commercial matters take a backstage. So we have to think of that how to diversify the legal procedures by alternative methods. In the latest amendment bill, which was introduced in 2024, I'm told there was a clause which probably has been deleted, that there should be an arbitral appellate tribunal. Arbitral appellate tribunal will take care of the objections under Section 34. At least one tier is off. And if there is a arbitral institution, appellate tribunal, the scrutiny would also be better before the High Court or before the Supreme Court. It was a welcome suggestion which was introduced. I think Law Secretary would be in a better position to say whether this provision is there or not there. But I'm told, I have not read it, that this provision has been deleted. These are then execution. Execution is again problematic. My suggestion would be, because I have been always advocating it, that we have a summary procedure of recovery under Second Schedule of Income Tax Act. And that provision is extended to the debt recovery tribunal, where the power is conferred on the registrar of the debt recovery tribunal to take summary proceedings for recovery. The court intervention should be reduced. You can authorize the centers or their officers to initiate recovery proceedings under Second Schedule of Income Tax Act. It will fasten the recovery proceedings, it will be summary proceedings, and it will not burden the court system. My idea is that people should not go to court for redressal of their grievances.
Thank you so much. Now that we've had the perspective from the former Justice Gupta, I would now like to see what the perspective is from a GC. So Mr. Chauhan, if you would please share your experiences with arbitration, that would be very helpful.
Sure. So from a corporation's point of view, very clearly, there was a time when the only intent on a commercial dispute was to get an interim order. And for that, the courts were the best place to be in. But after 1996, when standards have been international in arbitration now, and corporations now look at three things: efficiency, cost, and execution, and the level of confidence you have in an arbitration proceeding. So if I look at the last 15 to 20 years, I think that confidence is building. Certainly, there are more clauses, arbitration clauses and contracts. But in case we are still not there, in case efficiency, cost, and execution is taken care of, I think arbitration has come to a stage when it can be an absolutely alternate to litigation and may even supersede it. Thank you.
That's very helpful. And in fact, it's a very nice segue to our next topic, so to speak, which is you're saying now that efficiency is important, reliability is important. And so when, as general counsel, someone is thinking about a clause and you're negotiating a clause, the question that comes to mind first is, should I choose arbitration or should I choose litigation? You cross that hurdle and you say, okay, I'm choosing arbitration. But then the next question comes, all right, am I going to choose institutional arbitration or am I going to choose ad hoc arbitration? Perhaps I could invite Tejas to comment on that, given that Tejas is from the ICC. Tejas, you don't have a biased view, of course, but please tell me, what do you prefer, IC's institutional arbitration or ad hoc?
I always tell clients when I'm speaking with general counsels, good evening, everyone, please do not choose ad hoc arbitration thinking it's going to be cheaper, and do not rule out an institution thinking it's going to be expensive. That is point number one. Point number two is, the institution does not define the seat. You can have an SIAC arbitration in Paris, just as you can have an ICC arbitration in Singapore, where the ICC also has an office. And speaking of costs, the cost of an institution is perhaps just about 2% of your entire cost, which is going to be capped. 83% of your costs are legal costs. 15% of the costs are costs of an arbitrator. And when we speak about this institution being cheaper, that institution being more expensive, I have never heard a single lawyer say I'm the cheapest lawyer in Delhi. Nobody wants to advertise their services as that. So there are, of course, many benefits of having institutional arbitration. Number one is the predictability aspect, and I'm not going to touch upon it because I have, of course, the pleasure of having Shwetha, Mary Kay, who can also perhaps elaborate on that, but this is just something I want to touch upon.
Well, thanks very much, Tejas. Perhaps, Mary Kay, I might turn to you next, and let me see what your perspective is.
Thank you so much. And my respect and gratitude to those who are still here. Thank you for listening. We're tired and we're cold and we're hungry. I would like to actually make 3 salient points, having listened to other panels today and being in wonderful India. Point 1, we are here with General Counsel, and there's one thing that we lawyers need to remember. Users don't want to be users. They don't really like lawyers. They don't like to litigate, and they don't like to arbitrate. Users don't really enjoy the system of international arbitration anymore. It takes a long time, it is very expensive, and it's very hard to enforce the awards, as my fellow panelists have already alluded to. Point 2, and this brings me, and that's intentional, Your Honor, to the origins of ICA, because India is going to bid for ICA 2030, and I very much hope that we will see the ICA Congress coming back to India. The creator of ICA in the 1960s was Peter Saunders, and a dear friend of Vali Nariman. And he would talk about the national courts, because sometimes we do not give the national courts enough credit. And he would compare arbitration and the national courts to the bird and its nest. The young bird will fly away, but it will always find its way back to the nest, and the nest that is the national courts. So no matter how much we would advocate for arbitration, we will always need the national courts. And this is a little bit of a rude awakening. Sometimes the national courts need work. They need to be, the judges need to be pro-arbitration, they need to be versed in the New York Convention, they need to master the English language, they need to understand the essence of commerce. And that brings me to the last salient point. Again, listening to many conversations this week and the panel and the conference today, users don't want to be users. Courts have some work to do. And often we do these conferences with lawyers, but lawyers do not drive the debate. Users drive the debate. They affect change because they have that power, and governments do. And what's happening right now at a bilateral level, at a multilateral level, at the United Nations International Trade Law, is we're going to world courts and commercial courts, and users want mediation. And we've heard this a couple of times today, and I'm sure this entire week, and for weeks to come. Mediation in commerce and mediation in investor state, this is the future. And Bahrain very much hopes to find an alliance with India on promoting mediation together. It is hard to find the right mediators, but the users will want it. Now, why is that? Unlike arbitration, mediation preserves the relationship. And so those are the 3 points, and I wouldn't even want to get into institutional versus ad hoc because I am very much pro-institutional. Thank you.
Thanks very much, Mary Kay. So you've covered a couple of points, mediation, which I want to get to, but before getting to mediation, sticking on the theme of institutional arbitration versus ad hoc arbitration, it would be remiss of me not to ask Shwetha, who sits with SIAC. 66% of your users are of Indian origin, or that's a stat that I read. But perhaps you can tell me a little bit more about the growth of SIAC in India.
Sorry, what was your question again?
If you could tell me a little bit more, Shwetha, about the growth of SIAC in India and with Indian users.
Yeah, I think and I've spoken this last year as well, and every time we're back here with the Delhi Arbitration Weekend and the India Area Week, SIC's story is not complete without India, and I think in some way SIC has grown with the arbitration landscape in India, and very much supporting the growth of the businesses in India. And I think, we keep debating about between the institutions, after you get past the discussion about ad hoc versus institution, that which institution to choose. But at the end of the day, it's a service that an institution is providing. A service with a promise to manage your case effectively and efficiently. And I think SIC has been able to deliver to that promise to Indian users. We looked at the stats about last decade, we'd had over 2,400 Indian parties in about 1,500 cases involving Indian parties. But I think the number is not so simple in terms of just to speak of stats, but it's really the trust and that the user's been able to place in SIC. In fact, a lot of these arbitrations over the years have also been seated in India. So as India is becoming a stronger seat for arbitrations, and parties want an institution with a gold standard of case administration, they choose India as a seat and they take SIC as the administering institution. So in terms of very much choice, and I think it's for institutions, location is kind of agnostic, right? You could have an arbitration seated, like they just alluded to a little while back. You could have it seated anywhere in the world. But what is really that promise? And I think that's what also brings us back to the board, to continue to think, how can we do this better? How can we serve the users better? What is really the need? Where is the gap? And I think that has to be the central focus. We're talking about Viksit Bharat, we're talking about the growth for India, the vision for 2030 and henceforth. But really that growth story can happen if we stop talking about delays and accelerating costs and really have solid, efficient arbitrations. And I don't think anybody in the room would disagree to say that institutional arbitration is the absolute answer. The good thing is that we have a lot of options now in India. There's so many, there are domestic institutions, there are international institutions. Which institution to choose for can also be your type of disputes. What exactly, you look at the cost, you look at the experience of case management, you look at the enforcement track record, of the institution, what are the parallel arbitrators they have, what is the understanding of the kind of disputes. And even when we speak of, Indian parties, India is trading with the rest of the world, right? We're really out there. And you would see, structuring of the companies and, that comfort of neutrality. So I think SIC being able to serve and support and stand together and will continue to do so. I think it's very much part of the story. I think nobody in the world today doing business on an island alone. Singapore cannot, New York cannot, Paris, and India, we all have to be able to do it together to support wherever you can get the best from the world, right? I think that's my 2 point on it.
Thanks very much, Shwetha. One thing that you commented on and one thing that Marike commented on is really it's the users that matter, and the users don't want delays, the users don't want high costs, they want efficiency. And one thing that we are seeing, and Marike mentioned this earlier, is that mediation is sort of having another day today. People are turning to mediation often first before they go to arbitration. I have a little bit of a jaded view. Sometimes I wonder, is mediation really useful before going to arbitration? And on one day I think it's useful, on another day sometimes I think, no, really, if the parties wanted to mediate and sort it out, they could have. But I'd be interested to hear your views. Particularly, let's keep with you, perhaps, Shwetha, on the SIAC, SIMC, ARB, Med, ARP protocol. If you could tell us a little bit about that, I think that's a great innovation, and I'm sure our audience would love to hear about it.
I think, we all sort of unanimously agree that mediation has landed and has a very important purpose to serve. When I speak to the companies, They say, we want to run with the business, and we want to find the best way to be able to sort of settle this, right? But not every case can get settled, while that's the ideal case scenario in the world, to have, you can sort of maintain your relationships, you can continue with the businesses, and you don't have to sort of contest against each other. But the reality is there are some kind of disputes, some parties' objectives that able to sort of match and mediation works. But there are also large sort of disputes where they don't. We have a protocol with the Singapore International Mediation Center, which is the ARP protocol. And we've seen a number of cases over the years. And of course, some have succeeded under the protocol and some have not. While at SIMC, there's overall about 60 to 70% success rate of mediated settlement. But I think it's still, while we want it, it is, you still have to look at the nature of the dispute, and you have to look at the party's intent, when they get into the dispute. If both sides, one party wanting to settle is not enough. What is the other side looking at it? But we've made some changes to the rules to address this. Now there are specific rules in the recent revision of the SIC rules, which requires the tribunal to specifically ask the parties to go and try and mediate. Have they explored this seriously or not? To nudge the parties to be able to do that. And it's recognized as, while they could do it in principle, but there was no codified rule to that effect, which now there is in the rules. So I think everyone is taking note. In the practice, it is being integrated a lot more than before. Yeah.
Thanks, Shwetha. Tejas, would you like to comment on the ICC's approach to mediation?
Sure. The ICC also has mediation rules. There is a Center for ADR, which administers mediations under the ICC rules. What we see in practice is that mediation really works. Again, something that Shwetha has already confirmed. At the ICC, more than 50% of the cases are settled within the first hearing with the mediator. In terms of cost, again, something which is very efficient, because the average cost for an ICC mediation would be just about $20,000, whereas the cases run into $80 million, $130 million. We've had about 50 or 60 parties last year in ICC mediations. And how the rules promote mediation is that the arbitrators and the parties are encouraged to look at mediation. That is the wording that we use. And if the parties want to pause arbitration and get into mediation, the ICC will appoint a mediator free of charge, so that is administered mediation. And the ICC will also adjust the cost of the arbitration with the mediation itself, and vice versa. So again, this is how we encourage mediation within the rules.
Very helpful. Now, turning just immediately to your right, I think, I'm a little bit dyslexic, can't tell if it's your right or your left, but Mr. Chauhan, as a user and as a general counsel, how many of your disputes have you been able to successfully mediate?
Quite frankly, I mean, although mediation is mandated for commercial disputes, in my experience and experience of people I know about, it's a very poor rate in India, right? Because when you go for mediation, the belief of both the parties that they are right is extremely high. And maybe, second, third, fourth round, if the amounts are not large, or something of that sort. But typically, mediation is not having that kind of a success rate, what we understand in India, especially commercial disputes.
Yep. And this is not meant to be me as a speaker, but I will say I think mediation can be helpful depending on the type of dispute, and also depending on the time in which you're doing it. Sometimes it often helps to go into it as an arbitration, as Shwetha was mentioning, and then at a point in time, then say, okay, we've had our initial pleadings, I've seen your case, you've seen my case, now maybe it makes sense to come to the table and try to mediate a settlement. But it's not a one-size-fits-all solution, but certainly it's something worth exploring. Turning now a little bit more, the topic of the day today is how to build India's legal foundations so that its ADR system can become such that any other developed nation will want to come to arbitrate and mediate in India. And to have a successful arbitration and ADR system in India, you need to have trained arbitrators and mediators. So I'd like to invite comments from perhaps, Tariq, you might want to talk about this, what do we need in India to build a more robust ADR system?
Thank you very much, firstly, and good evening to all. Since we are talking about 2047, I think it's important we look back and see where we are coming from as India. Indian arbitration ecosystem is not new. It's not, people think it's the 1940 Act, which was the first act, which is not correct. It used to be the 1899 Act, which was only extended to 3 provident states. Thereafter, the 1908 CPC had Schedule 2, which was dedicated to arbitration. Then we had 1940 Act, which suffered from various problems, and I'm reminded of Justice D.A. Desai. On 29th September 1981, he was dealing with a case, Guru Nanak Foundation versus Ratan Singh. What he said is very interesting and relevant for us to look back. Interminable, time-consuming, and expensive court procedures impelled jurists to explore the alternative to the court system, and that led them to the Arbitration Act of 1914. However, the way in which the scheme of the act has been implemented, and every award without exception has been challenged before the court, has made lawyers laugh and legal philosophers weep. Now, this is where we are coming from. That's where the 96 Act came into the picture. It had its own issues. Arbitrators were taking arbitrations for 10, 15 years. Fees was exorbitant, and nothing was ever getting over. Everything changed on 23rd October 2015 when the amendments were brought in by the Government of India, which completely changed the shape of arbitration landscape, which was followed by, of course, other amendments in 2019 and 21. And I must commend the Government of India for these amendments, because that's when we actually got better than many other jurisdictions, and it has become a trend to criticize India in global conferences, whereas we are doing much, much better. And the Indian ecosystem is doing exceptionally well. Now, what is lacking very quickly, I know I'm running against the clock. In all these arbitration weeks and arbitration conferences, the topic is how to become a hub of arbitration, where in fact nobody really talks about what would it entail to become a hub of arbitration. It's very simple. First and foremost, you need a robust arbitration law to create an ecosystem, which India has now in place. The 1996 Act has been amended, and I think it's pretty much in a good shape. The Law Ministry is again doing an exceptional job. They're inviting comments, and reforms are ongoing. The second thing which is important to have a robust ecosystem is the support from the judiciary, which means a judiciary which is enforcement friendly and enforcing arbitration agreements also, not just arbitral awards, which I think to a great extent Indian Supreme Court has done a phenomenal job. The third is you need a world-class arbitral institution, which now we do have in India, and I think that's really good, with a flexible and world-class rules, which we have in place. The last thing which is important, and people think it's the most important, is the infrastructure, which I do not think is as important as it is projected. What India now lacks today, to my mind, and where we can really make a difference, I think the panelists have already covered that. It's a push from the courts, which is required for the institutional arbitration, because as long as the courts are appointing arbitrators and keeping it with them, that's where the real problem lies. And that's where Dubai as a jurisdiction and DIAC as an institution is making a lot of difference and remains the largest institution in that part of the world, because none of the awards in the DIFC courts have been set aside in the last 20 years. That is the level of pro-enforcement jurisdiction we are talking here. So when I'm seeing, as a practitioner of DIFC court and as a user of DIAC, I see the quality of awards is best, and I have not seen those kind of awards, and nothing is being set aside. I was trying to actually look for a DIAC award which has been set aside, and I couldn't find anything. So as a user, this is the institution that I want. Thank you.
Thank you very much, Tariq. Actually, keeping with that, the quality of awards, I'd like to hear a little bit about scrutiny of awards. And I know some institutions offer that, some don't. The ICC is notable in that it does offer scrutiny awards. So perhaps, Tejas, you could comment very quickly on it.
Sure. The ICC has a 3-level scrutiny, and what we mean when we say 3-level scrutiny is that the ICC court is involved. We use the word the ICC International Court of Arbitration, and it's very funny because the whole idea is to get you out of the court. But the court is a body that is made up of 190 members and led by a president. So every award within the ICC rules cannot be notified to the party unless and until it has been approved by the ICC court. Now again, there are 3 levels to this. First the Secretariat, then the Managing Councils, then the court. But how it works in practice is that we see on average every year 10% of the awards are not approved and sent back to the tribunal to redraft. 98% of the awards will have comments from the ICC, so they will benefit from some level of scrutiny. Now, without getting into the technicalities of what we address and how we address, given the paucity of time, I would say that the ICC, all of this process is a human process. The ICC does not claim that we have a 100% enforcement record, and we do not say that no award has been set aside. It is a human process, and it is dependent also on the interpretation of the courts. So in short, this is how we do scrutiny.
No, very helpful. And touching again on something that Tariq mentioned, and he spoke about the wonderful developments that are coming out of the law ministry, and we're really honored to have with us today the Secretary of the Department of Legal Affairs, Ms. Rathi Rana. And Ms. Rana, if you could please comment a little bit about what you are seeing at the ministry and what policy changes are being made to make India a hub for ADR and arbitration, I'd be very grateful. Of course.
All the esteemed panelists on the dais, all the esteemed guests at the conference room, and today's session moderator, a very good evening to all of you. So, with regard to India's and the Government of India's perspective, my thoughts will revolve around from the policy angle. So, over the decades, the Government of India has taken consistent steps to modernize its framework with regard to the arbitration. In this regard, the Arbitration and Conciliation Act 1996, with its subsequent amendments, has made arbitration more time-bound, transparent, and globally competitive. The establishment of Arbitration Council of India with an aim to build world-class arbitral institutions in India at par with other international institutions in Singapore, London, and Paris. And a defining moment comes in 2019 with the enactment of New Delhi International Arbitration Center Act, now renamed as India International Arbitration Center Act. With this legislation, IIAC was established as an institution of national importance, and this declaration reflects the Government of India's resolve to make India a serious player in the global arbitration landscape. Ladies and gentlemen, the draft Arbitration and Conciliation Amendment Bill 2024, currently under deliberation, proposes further reforms such as 60-day timeline for disposal of key court applications, shifting procedural powers from courts to arbitral institutions, and reducing regulatory overlap. And these steps aim to cut backlog, improve efficiency, and enhance business confidence. All these reforms align with our Honorable Prime Minister's Narendra Modi's vision of Viksit Bharat 2047, which is the theme of our today's deliberation. A future-ready India built on ease of doing business and ease of justice. He has envisioned India as a global hub of arbitration and in 1922, while addressing the joint conference of Chief Ministers and Chief Justices of High Courts, our Honorable PM posed a compelling question. I quote, "In 2047, when the country completes 100 years of its independence, what kind of judicial system would we like to see in the country?" Unquote. It was more than a rhetorical question. It was a call to introspection. He emphasized that mediation in our justice system is not just a tool for resolving pending cases, but a reflection of our age-old tradition of dispute resolution through mutual consent and participation. He noted that mediation reflects a distinct human concept of justice, one that has long existed in the fabric of Indian society, even outside the formal courtroom. And this is true. India has always believed in the principle of samvad, dialogue before discord. Mediation is not new to us. It is part of our culture, from the village panchayat to modern statutes. Mediation in India has long existed in statutory form, as well as beginning with amendments to the Code of Civil Procedure. Building on this vision, the Ministry of Law and Justice, Government of India has introduced Mediation Bill 2023, which subsequently culminated into the enactment of Mediation Act, a step towards institutionalizing mediation as a mainstream mechanism for dispute resolution. We at the Department of Legal Affairs, Government of India, Ministry of Law and Justice are deeply honored to be carrying that vision forward. We are giving form to the Honorable PM's aspiration of justice system that is more accessible, more empathetic, and more in tune to the evolving needs of our country. In simple terms, a system that heals, not hardens, that includes, not intimidates. Over the past decade, many obsolete laws have been repealed to declutter the statute books. The enactment of Commercial Courts Act 2015, the subsequent amendments to the Arbitration and Conciliation Act and launching of the Mediation Act 2023 have significantly improved access to justice. Ladies and gentlemen, we want to make ADR not the exception, but the norm. It is not about catching up with the world. It's about moving step with it and often leading by the example. The future of ADR is the future of justice, and that future is now. In today's India, a nation determined to rise as a global economic power, our dispute resolution mechanism must reflect our aspirations and must match the pace and precision of our commercial ambitions. Thank you.
Thank you so much for the address. With that said, I'm pleased to report we are ahead of time, but one thing that I have to do is say an individual thank you to each of you. Thank you so much for your time and for coming here today and sharing your thoughts and your experiences. Thank you.
Thank you so much to all of our guests. I would request you to please stay on the dais as we start with the felicitation. I would please like to invite Ms. Lubnisha Shaha, Founder, GCAI, Head of Legal and Compliance, South Asia Airbus, to please do the felicitation. Thank you so much, everyone. Thank you.